And dad admits that he works second shift. We issued some discovery, and he admits that those are his work hours. And so basically, he's not there for the child. The child gets out of school at like 3 in the afternoon, and dad's basically already at work, and he's not there. And so, but it wasn't a problem because he he stopped exercising his Wednesday and Thursdays, and when he started working at Spirit. Um, so it really wasn't a problem at all. But in September of 2025, for some reason, he just started enforcing the old court order and said, no, I want my Wednesdays and Thursdays. I want to start exercising them. And mom reluctantly agreed because it was the court order. And she was asking him who's watching the kid. He refused to tell her. It's none of your business, because she knew that he was still working second shift. Well, come to find out, he was having his girlfriend watch the child. And so basically, the Wednesdays and Thursday parenting time is for his girlfriend instead of the mom, who's a stay-at-home mom and available to watch the child. So in November, so that was in September. In November, she finally was like, "This is ridiculous. Why he won't communicate with me about who it is?" Um, and so she came to me, and we filed this motion. A couple days prior to the hearing, he hired a lawyer and continued the case, and so that's why it's been so long before we've been able to get into the court. But it's a pretty simple motion. She just basically, her parenting plan is basically just eliminate the Wednesdays and Thursdays, and he can have every other weekend. She would be fine for him exercising the parenting time if he was going to be there, but she just doesn't understand why his girlfriend is getting the parenting time instead of the mom who's available and able to watch the child. And so basically, we're asking the court to adopt our parenting plan, which just eliminates the Wednesdays and Thursdays, gives him his every other weekend that he had before, and orders child support per the guidelines. And unfortunately, like I said, Judge, we've been waiting. She's been waiting 4 months to get into court just to be able to have that parenting time instead of his girlfriend having the parenting time. So that's all we're asking for.
All right. Mr. Thompson, Mr. Hawley has laid out, I think, two important material changes of circumstance. One, he alleges that the parties established, in essence, a new de facto parenting plan where Wednesdays and Thursdays were essentially eliminated for a substantial period of time. His second assertion is that your client works second shift and is simply unavailable to provide actual parenting guidance on these Wednesdays and Thursday evenings. Are these facts disputed?
They are disputed to a certain degree, Your Honor, if I may. Thank you, Your Honor. May it please the court. First, to address I believe Mr. Hawley just made a misstatement, but it is a material misstatement. Mom is not a stay-at-home mom. She does not stay at home to care for the 6 children that live in her home, Your Honor. She works, at least according to discovery that we received Friday. She works hours that are from 11:30 a.m. to 7:30 p.m. at T-Mobile in El Dorado, Kansas. Mind you, she lives in Douglas, she works at T-Mobile. So I'm not sure where this is the first I've heard that she is claiming to be a stay-at-home mom, unless between Friday at 5 o'clock when we received the discovery responses and today she quit her job to stay at home, Your Honor. So just that, she's not a stay-at-home mom. She works evenings, according to her discovery, until at least 7:30. It's my understanding she's in sales at T-Mobile. So even though it says you clock out at 7:30, you're not done at 7:30 necessarily. There is at least a 30 to 45-minute commute from at least 30 minutes, according to Google Maps, from the T-Mobile store in El Dorado to her home address in Douglas. And that's assuming that there's nothing else going on. So, Your Honor, she's also gone of the evenings until at least between 8 and 9 p.m. This is an 8-year-old girl, Your Honor. She's not going to stay up much past 9 p.m. Once again, in the discovery response we received Friday afternoon, mom is using her live-in boyfriend. There's been 2 domestic violence cases involving those 2 parties to take care of the girl, along with boyfriend's stepdad, who also lives in a double wide, Your Honor. So she is using those 2 folks that live in that manufactured house for daycare. My client, based upon, this is where an evidentiary issue comes in. My client says there was an agreement between the parties that until he has an established relationship with his current significant other, Josie, he was going to exercise every weekend visitation. Every weekend. My client has been with Josie for years. How long? 2.5 years, Your Honor. So he felt that the relationship was established enough. She lives with him. In September of 25, that's when Dad said to Mom, hey, I think Josie and Emma have a relationship. It's a good relationship. I think it's time to start shared back up again. Then shared started. And then 2 months later, she files a motion, Your Honor, after it went back to shared for 2 months. So for those 2 months, shared, nothing going on. Then we get into what we believe is some money issues. She wants more child support. Your Honor, once again, in a discovery that was said, she has an opioid dependency. She is on, I can't pronounce it, the opioid dependent drug, which I cannot pronounce. I apologize, Your Honor. She is on that. She put that in the discovery. She's been on that for over 5 years, Your Honor. I think closer to 7. She's also on Adderall. She has ADHD. So there are some significant issues involving substances and Mom that's of concern to my client. We also have concerns with the providers that she disclosed in her discovery that are watching the kids during her time. We learned of no issues with Josie, but with Nick, the boyfriend with the 2 DVs against Christian, we have information that leads us to believe there's been substance abuse with him and his stepdad, Your Honor. So we need to get into that too. We also have concerns with Mom's household. It's our understanding now there are 6 children between Mom and this Nick, 4 bedrooms. So we have 3 adults in the house, 6 kids, 9 people in a 4-bedroom, double wide manufactured home in Douglas. We have concerns about that home relationship. We think that Ms. Ross may have just had a child or is going recently. We're not sure of that, but we think there may be an additional child in this home as well, a newborn. We don't know that for sure, Your Honor, but we have information from third parties that leads us to that conclusion. So Your Honor, my client works second shift. No question about that. Ms. Ross did disclose that she works evenings as well. She is not, notwithstanding the counsel statement, a stay-at-home mom. She's working evenings at T-Mobile in El Dorado, Your Honor. We had shared parenting time. We had a relationship with Dad and girlfriend. Dad, to Dad's credit, said, let me get established in my relationship and do every weekend until that time. Establish a relationship. Josie, who is his significant other, has a great relationship with Emma. She takes care of Emma. Dad takes care of Emma primarily. He takes her to school. So the second shift allows him to take her to school. So he's got to drive her to school. He lives in Augusta, school's in Douglas. So he takes her to school. He picks her up from school when he's able. And for the next 3 weeks or so, he has schooling at Boeing to learn a new skill.
Yes,
manager training. So he is off early enough where he can pick up Emma from school and spend evenings with her. So while his schedule is typically second shift, there is some flexibility depending on what goes on where he is spending evenings with Emma. But Your Honor, it's not that Mom can take care of Emma full time every evening. That is simply not true. She is not a stay-at-home mom. There are also 6 kids, to our knowledge, maybe 7, in this home where she has a bunch of different folks that she has to take care of. Emma is going to get attention at Dad's home. It's in Emma's best interest to maintain the relationship with Dad, Your Honor. And we have serious concerns, which when I read, and I am new counsel, I read through these materials, I anticipate we will file a motion for primary parenting time based upon some of the issues that we have. And we're going to need further discovery because the discovery we received Friday afternoon was somewhat lacking. We asked a specific question, how many folks have spent overnights in your home since a date certain? And Mom had answered 0. Well, that's simply not true. Someone's spending the night in this house, or else where are they staying? So we've got some additional discovery issues to ferret out, and it may take a deposition. But Dad is concerned about the stepdad, friend, a boyfriend living in that home. If there's 6 kids, which weren't disclosed, we know there's more than one. And the toxic home environment with the boyfriend having 2 DVs involving this mom, and they have separated in the past. So we think this is a relationship that is on again, off again, on again, off again, involving violence and drugs, Your Honor, which is not in the best interest of this child. So Dad needs to maintain a presence. And Your Honor, just because a parent's working doesn't mean that that parent should not have parenting time, especially when he has a long-term over 2 years, pushing 3, significant other with an established relationship with the child, while mom has a relationship with someone that's off again, off again, on again, off again, that's had domestic violence against mom, Your Honor. So between the two households, dad ought to at least maintain the shared parenting time. And we teed up an evidentiary hearing to determine whether one or which parent should get primary if shared is not in the cards for these folks, Your Honor. I believe that, Your Honor, of course, there has to be a prima facie case to get us to an evidentiary hearing, Your Honor. There is the change of circumstance that my client has been on second shift, even though since September they have been exercising shared parenting time, motion filed in November. We believe that there would be a prima facie case for dad to have primary parenting time, and we are going to file a verified motion with pretty significant factual allegations involving mom and her home situation.
Mr. Thompson, a couple of questions. Did these domestic violence incidents that you described result in convictions?
They were in 2015 and 2020. I do not recall, Your Honor, if they were diverted or if they resulted in convictions. I apologize. I do not know the answer to that.
Would seem like some fairly ancient history, Mr. Thompson.
They are dated, Your Honor.
All right, second question. Did your client refuse to disclose to the mother of this child who was providing substitute care for extended periods when he was working?
No, Your Honor. I apologize for not addressing that in my argument. There are many text messages, and I indicated that to Mr. Hawley as well in a conversation last week. Many text messages. Mom, from how I read it, Your Honor, it looked like it was a litigation strategy. She would ask frequently, who's watching? My client would say Josie. Who's picking up? Josie. And there'd be significant periods of time where mom wouldn't ask. And then mom would also acknowledge Josie's picking up Emma. Yes, mom has met Josie. They have had exchanges. Your Honor. So no, Josie is not a secret, Your Honor. My client most certainly did not withhold that information, Your Honor. That was not in Mr. Hawley's motion, or I would have provided as exhibits the text messages, because these are not all a lot of these are text messages, Your Honor. Not all of them relate to disclosing Josie, but a significant number of them do, Your Honor. But I tried to stay within the page limitation when my exhibits were due last week, Your Honor.
All right, Mr. Hawley. You had represented to the court earlier that your client's a stay-at-home mom. Would you now modify that statement?
When I do apologize, I don't know why I said that. Basically, she does work at T-Mobile. She works basically 8:30 to 5. The 11:30 to 7, she simply put that in her discovery because occasionally on an off Saturday or something when she doesn't have Emma, she will work 11:30 to 7, but that's very rare. So her husband works at Spirit also. He gets off at 2:30. He's home by 3. The kids take the bus home from Douglas. They're there about 4:30, and then my client arrives around 5:15 at the house. And so she's there right when the kids, shortly after the kids get off the bus. I will say,
Mr. Hawley, is this fellow that she lives with a husband or a boyfriend? You said husband, so and Mr. Thompson referred to him as a mere boyfriend. So
we have 5 children together.
They have 5 children together. They are not married, and I apologize. They are not married, but they've been together for quite some time. They have 5 kids together. Again, she's home right after the kids get off the bus. And I will say that the dad, Mr. Leedy, and Josie just filed a PFA against my client. When they learned that she was going to be filing this motion, the PFA was actually dismissed by this court. Mr. Leedy did not show up. His girlfriend Josie showed up, and the court, after hearing evidence, dismissed it. So there's a lot more going on here. I would agree with that also. But the bottom line is that mom is there and available to watch the child, and he is not. And both parties agree on that one fact, if they agree on nothing else. And so the parenting time should not be for the girlfriend of Mr. Leedy. It should be for the mom, and she's available in there. And if they want to have an evidentiary hearing, Mr. Thompson entered his appearance months ago. Why haven't they filed a motion now? Clearly, it's just to avoid the child support that mom deserves, because she's had the kid for the last 3 years until he started enforcing this and allowing his girlfriend to have his parenting time.
Your Honor, just to correct another misstatement. That is not 3 years. Mr. Hawley said 3 years. That is not true. Joyce Demo or shared parenting time, that lasts until January 24, went through probably September of, well, I'm sorry, from January 24 through September of 25. So a year and a half, Dad had every weekend to establish this relationship, which seems to be good co-parenting in my view, Your Honor. We have a relationship. We want to make sure it's a stable relationship. He doesn't have 5 kids with this woman. That's obvious, but it is to the point where it was stable, go back to shared, which he says was the agreement of the parties. Once that took place, shared comes back. It did. There wasn't a motion filed between January of 24, when he started at Spirit, now Boeing, until November of 25. Mom could have, Mr. Hawley says Dad could have filed a motion for what? I just got in this case. I won't explain why we had to get one continuance, but been a little under the weather for 4 weeks. But, Your Honor, Mom had, according to her, a year and a half to file a motion to change to primary parenting time. She didn't do that, Your Honor, not at all. And the PFA had nothing to do with Mom filing her motion, at least from Dad's point of view. It involved her boyfriend, Nick. My client's girlfriend believed Nick was harassing her and making comments. And that is my understanding. I was involved in that. That's my understanding for the basis for the PFA. Nothing to do with this motion or anything like that, Your Honor. But I want to make sure we had facts clear. We've heard husband, we've heard stay-at-home mom, we've heard 3 years. None of those things are active, Your Honor. We've got a boyfriend, we've got someone who works, at least according to your discovery, she says 8:35 p.m., then 11:30 to 7:30 p.m. We don't think it's just on the days, the weekends when Mom doesn't have Emma, Your Honor. And that's also a discovery issue. We can subpoena her employment records from T-Mobile, which we're going to have to, it sounds like, to see if she's telling us the truth or not. And Mr. Hawley's representations of what she's telling him is the truthful. Because we believe it's more than just the occasional Saturday, once or twice a month, Your Honor. That it's much more frequent than that. And, Your Honor, we do not believe, well, we believe that an evidentiary hearing is appropriate because there are several, we've heard several misstatements, just an argument, Your Honor. We believe there are facts that are in dispute and will continue to be in dispute, Your Honor. And we need to determine what's in the best interest of this child. We've heard nothing about anything wrong with Josie, and it is not unusual when you have working parents to have significant others care for children. That is the norm. You do not have a parent taking care of their children 24 hours a day, 7 days a week. Parents have to work in order to support the children. That's happening at Mom's house. That's happening at Dad's house. So Dad should not be punished for that, Your Honor. And he is taking every opportunity to be with his child. We've got, this isn't the evidentiary hearing, but we've got photographs, going to school events, taking her out, doing things, Your Honor. And Mom admits in argument that she's not meeting the kid up at the school bus. She's getting home at, if she's working until 5, between 5:30 and 6 at the earliest, Your Honor. So the daughter's been home for 3 hours, 2-3 hours at least, give or take. So, Your Honor, it's not one where we've got a stay-at-home mom and Dad is working 80 hours a week. We've got a dad who's working 40 hours a week, a mom who's working 40 hours a week. Mom is not with the child the entire time the child is available to be cared for by a parent. Neither's Dad, Your Honor. Mom has third parties taking care of the child when Mom's away. We have some issues with those third parties, Your Honor. We need to get into those. Dad has someone taking care of the child when he's away. Heard nothing about her, Josie, nothing at all. So, Your Honor, this is a case that it appears an evidentiary hearing is necessary to determine what's in the best interest of this child, Your Honor. There are some serious substance abuse issues that need to be addressed with Mom. We got the discovery Friday afternoon, and I served Mr. Hawley his discovery Friday afternoon as well. So it's on the same day, where we have an opioid dependency medication that's being taken for over 6 years, 7 years. That seems unusual, Your Honor, that we're still taking that opioid dependency medication for that period of time. We're also taking Adderall, Your Honor. So we've got a cocktail of drugs that we're taking, along with credible information that Rick and Nick, who live with Mom and these 7 kids, I mean, she said she had 6, I think, with her boyfriend, 7 kids are subject to. So there are some very significant, important issues, Your Honor, that I believe we need to have evidence on to make a decision that's in the best interest of this child.
Judge, if I may, the bottom line, he just keeps repeating the same stuff over and over. The bottom line is is that my client's home at 5 o'clock. He works from 2 to 11. He's not there at all. And his girlfriend is watching the child. Nobody disputes these facts. What does it matter if it's 3 years or 1 year? When he started enforcing the shared custody agreement, whereby his girlfriend was watching the child, she filed a motion to change custody. He did absolutely nothing.
Mr. Hawley, it begs the question, during this time that there was a new de facto parenting arrangement in place, why didn't she file a motion to have the court confirm it?
She did. He started enforcing it in September. She was texting him and saying, hey, what's going on? Who's watching the kid? Are you still working second shift? These parties obviously don't communicate with each other. And then she came to me and we filed this motion right away. We filed it in November. We wouldn't, and as I said before, when we came for hearing, 2 days before that, he hired a lawyer and got another continuance. So we've been waiting 4 months, November, December, January, February. We've been waiting 4 months to get into court just so we could tell the court that the mom's available to watch the child instead of the girlfriend. I think it's a very simple case. They're trying to use all these smoke and mirrors of some made up addiction thing, or that she works till 7 o'clock when she doesn't have the kid. None of these things are true. And I apologize to the court for my misstatement that she's a stay-at-home mom. I know they're beating me over the head with that, and I get it. But she's not a stay-at-home mom. She gets home at basically when the kids get off the bus from Douglas. But there's no reason for the girlfriend to be watching the child when the mom could be watching the child. And they haven't made any motion to change custody otherwise. And what are they going to? I mean, they're going to make a motion to change custody so the girlfriend can watch her all the time instead of just 2 days a week. Maybe the girlfriend can watch her 5 days a week. So, I mean, I think it's a pretty simple case. If they want to file their motion to change custody, bring it on. We're happy to address any of those issues that they may have. But the bottom line is, dad's not available during his parenting time Wednesday and Thursday. Mom is available during her parenting time, and the court should eliminate those 2 days and order that and our child support worksheet that we submitted to the court as our exhibit C.
Your Honor, just briefly, correcting misstatements. That's all I'm going to do. Mom does not get home at 5 pursuant to her own discovery. She does not get off work according to her own discovery responses. One, she says 8:30 to 5 p.m. and then just a dash, 11:30 a.m. to 7:30 p.m. If she gets off work, let's say at 5 on the dot, in sales, we all know you don't get off work at 5 on the dot, she cannot automatically transport herself from El Dorado to Douglas, Your Honor. There's a minimum 30 minutes. So when Mr. Hawley says she's home at 5 or right off the bus, those are 2 different things. 5:30 is the earliest that she's home. Bus, I think Mr. Hawley said, I don't know if it's right or not, between around 3:30. So there's a couple hours there where we have Nick and Rick taking care of Emma, Your Honor. That's the minimum. She also said that she gets off work in El Dorado at 7:30. We don't know how many days she's supposed to put that in her discovery responses. She didn't. We don't know how many days of the week she does that. So that puts her 8 to 9 in that time frame as well, Your Honor. So that's the first misstatement, Your Honor. The next misstatement is, we didn't make up anything about addiction, Your Honor. That's in her discovery responses. I didn't create this out of whole cloth. I may not be able to pronounce what she's on, Your Honor. I can spell it, but she is on BUPHRENORFINE, her own discovery, opioid dependence. She's also on Adderall for ADHD, Your Honor. Those 2 things. I didn't make those things up. Those were in the discovery responses that we received. We have information that leads us to believe that Nick and Rick have substance abuse issues. Didn't say they did. I just said we have information to believe. Mom's discovery tells us this, Your Honor. I just want to make sure the record's clear, because a lot of things are being thrown out. A lot of them are inaccurate, Your Honor. I'm just trying to get the record clear so the court can make an informed decision.
All right. The court's initial or threshold decision to make in this case is, should the motion filed by Mr. Hawley go forward? I'm at this time considering the imaginatively entitled motion that was filed back on November the 19th, which in essence, in the text, does seem to ask for a change in the parenting plan orders which are currently existing. The court does find that that motion does set forth sufficiently a claim for material change of circumstances that would warrant alteration to the parenting plan. So the motion filed by Christian Ross will go forward. in this case. The court is in no position to rule on a motion that hasn't been filed. Whether there's any validity or factual support for some of the claims that the father is making in this case, this court cannot determine. Because quite frankly, there is no verified motion for any other alteration of the parenting plan currently before the court. However, I do agree with Mr. Thompson that an evidentiary hearing is warranted here, and the court will set a date for that hearing with the admonition that if you're going to file any type of responsive pleading or motion for your own claims of change of custody or alteration of the parenting plan, the court's going to set a strict deadline of 14 days from today's date to get that on file. The court will consider any of his claims currently abandoned if that's not on file within 14 days from today, Mr. Thompson. And I do, to a certain extent, I think Mr. Hawley and his client have been compromised today for the assertions that he's orally arguing a motion that's not on file and hasn't been verified and hasn't set forth sufficient facts to support any claims for alteration of the parenting plan. But 14 days from today, Mr. Thompson. I do detect here that there's going to be further discovery. Sometimes depositions are necessary and appropriate to kind of ferret out some of the factual discrepancies which may exist that sometimes written discovery leaves open. So allowing for a period of discovery, I think the court's contemplating perhaps an April date for hearing in this case. The date I would propose would be Tuesday, April 14, counsel. Tuesday, April 14. Mr. Hawley.
That's fine with me, Judge.
Your Honor, I am not the keeper of my calendar. May I confirm that with my secretary, Aaron, who can let your AA know?
Please. Okay.
Yeah, I don't want to mess it up.
Can you check now?
Oh, yes, Your Honor. Excuse me,
Confirm with your keeper.
May I be excused?
You may. I hope we haven't lost Mr. Thompson.
Sorry, Judge, as luck would have it, she was in the restroom. April 14th, I have an out-of-county hearing, so I'm unavailable then.
Do you have a handle on the rest of that week?
Yes, Your Honor. I can do April 15th.
What about the 17th, Thompson?
I'm sorry, Your Honor.
17th?
I believe so. Erin is double checking one thing and she's actually bringing it down. I believe so, Your Honor. That is my 60th birthday, so I think I have that day off. So, but if we need to get a trial scheduled, we can.
Well, look, I don't want to interfere with some sort of compelling personal plan that you might have. I really don't want to do that.
Okay, Your Honor. I know my wife was.
Your willingness to give up your birthday celebration.
I know my wife was secretly planning something, but it's not a big secret when you have kids.
Though I would prefer not to start cases like this on a Monday, I can offer Monday, April 13th.
I have a 2:30 hearing that day.
Let's see if I can go slightly back.
Excuse me.
And Mr. Hawley, could you just check while we're waiting on Mr. Thompson for April 7, 8, and 9? Any of those 3 days? That's a Tuesday, Wednesday, Thursday, 7, 8, or 9 of April.
Thank you, Your Honor. I brought the boss too, so if she can make sure, interpret my calendar. This is Aaron, Your Honor.
I'm looking now at dates of April 7, 8, or 9.
April 9, Your Honor.
Mr. Hawley?
I could probably make not the 9th work. I've got a hearing, but I think I can move it. I'm pretty sure I can move it. So I can make the 9th work.
All right. I think Mr. Thompson's confirmed the 9th will work for him.
Yes.
So the court will set an in-person proceeding, courtroom B, Butler County Judicial Center, in this case for Thursday, April 9. There's a full day setting. I want exhibits from the parties in notebook form. You can present it day of trial as long as you've shared those exhibits either in notebook form or electronically with the opposing party by no later than close of business on Monday, April 6th. I want opposing counsel to have at least a couple of days to look over whatever exhibit submissions you're intending so we can cut down on objections or delays. So to opposing counsel by Monday, April 6th, again, exhibit in notebook form presented to the court on Thursday, April 9. You can deliver those earlier if it's easier for you, but presenting those in court is acceptable since it is an in-person proceeding.
9 a.m. Thursday, Your Honor.
That is correct. April 9 at 9. And then again with a 14-day deadline for any opposing motion or any written response that you're filing to Mr. Hawley's motion. Mr. Thompson, any questions about that?
No, Your Honor, just making sure I've got, Your Honor, no questions.
All right. I know that there's already been some discovery that's already been initiated. I just hope that the parties realize that April 9th will be here before you know it. So the sooner you can get additional discovery scheduled or sent out, I don't want to see any delays because of discovery issues. But I know that experienced counsel that are on this case certainly will contemplate that and make sure that they do appropriate scheduling and submission accordingly. All right. Mr. Hawley, anything else that we need to address currently?
Yes, Judge. I would like on a temporary basis going forward, there's no reason. I mean, if the court wants to implement 2-hour right of refusal, if either parent's going to be away from this child for 2 hours, the other parent ought to have the ability to watch the child. If their allegation is true that she's working until 7 or 8 at night, whatever, then he can have his parenting time. But my client's available to watch the child, and there's no reason for his girlfriend to be having the parenting time until we get to trial. She's been living under this problem since September of this year when he unilaterally just started enforcing the parenting time agreement. So we've been waiting since November to get a ruling from the court. There's no reason for the child to be with the girlfriend when the child can be with the mother. And so we would like on a temporary basis, or at least until the trial, for the court to allow the mother to have the parenting time that the father's not exercising.
Your response to this temporary parenting plan, Mr. Thompson?
Your Honor, I do not believe that it is in the best interest of the kid or the child or appropriate, Your Honor. We have discovery when Mr. Hawley argues that, well, they claim she gets off, she has to work until 7 or 8. We're not claiming it. That's in your discovery responses. I read the exact discovery response, Your Honor. That is from the sworn interrogatory responses we received Friday afternoon, Your Honor. We're not making it up. So she is not there all the time for the child either. We have working parents, Your Honor, trying to, well, what Mr. Hawley's asking for is a modification of the parenting plan based upon a standard or Zoom motion without the benefit of evidence or due process, Your Honor. That's inappropriate. There are factual disputes in place. It sounds like we have either inconsistent discovery responses with Mr. Hawley's argument, or there is something amiss here about her work schedule. I don't know what's so secret about it. They said she gets off work at 11:30 to 7:30. That was the extent of their response for that time. She also mentioned the getting off work at 5, Your Honor. Both parties are not going to be with the child the whole time. There's no reason to accept this parenting plan on a Zoom hearing without the benefit of evidence, Your Honor. And the court pointed out, we never got a direct answer for it, that if Ms. Ross was concerned about these issues, she had until from January of 2024 until she filed her motion in November of 25 to file a motion to adopt whatever she thought the status quo was. She did not do that. She waited until months after shared parenting time started to file her motion. The court asked that question, never got a direct answer to it. I brought it up in one of my arguments here. So right now we're trying to push this without the benefit of evidence, Your Honor. And it appears to be a money issue. We got a child support worksheet. She wants to get a significant amount of child support, Your Honor. I think that's why we're pushing it instead of waiting until April, Your Honor. We have a very expedited, it seems to be an expedited hearing setting, which is fine. The court is not putting this out until July or August. We're having it in April in a couple months, Your Honor. So it's not a significant period of time. And the parties have already been doing this from September. And keep in mind, mom waited 2 months to file her motion from September even though she had a 1.5 years prior to file a motion. So there's no reason to adopt a temporary order modifying Joyce Nemo's, the parenting plan that was adopted by the court.
Judge, this is ridiculous. He started working second shift and stopped exercising his Wednesdays and Thursdays. If the mom wanted money, she should have filed it back in 2024 when he stopped exercising, but she didn't because everything was fine. She didn't care about the money. She just wanted the parenting time. And then in September, when he unilaterally said, no, my girlfriend's going to start watching the kid. Well, he wouldn't even tell her who was watching to begin with. Then she came and got me, and we filed a motion to change custody. And the only reason we've waited so long is because we couldn't get into court until now.
And Your Honor, this was not a unilateral decision. My client, there's another evidentiary, she said there was an agreement with the parties. Get the relationship with Josie established, that happened, then the shared parenting time resumed. And then she filed her motion after that's been going on in a couple, 3 months.
Why would she have filed her motion?
We go back and forth endlessly here. The court's prepared to rule on Mr. Hawley's request. Mr. Hawley, I understand the reasoning behind your request today, but the court's going to deny it essentially for two reasons. Number one, and I understand that you've acknowledged that you made a mistake on this representation earlier, Mr. Hawley, and I fully accept it. but your client is not a stay-at-home mother. She herself has significant times during the evening that she herself is not available to spend time with Emma. That's certainly one consideration for the court. If she were indeed a stay-at-home mom, the court very well may view this issue. But there's another reason why the court's going to deny the request is that there is an established plan that's in place for this school year. Commencing with September, a new schedule has been established. Emma is used to that schedule, and there's been no showing that it is contrary to her best interest at this time to continue, at least temporarily, the plan which is currently in place. It's at least consistent with what appears to be the schedule that Emma is currently following. And I understand that the court is concerned that the father is not there to spend evening parenting time, but there's also been no showing that Emma has been materially compromised by the plan that the father has put in place for substitute care at this time. We need to sort this out. And I think it's going to take an evidentiary hearing development to sort it out. So the temporary request is denied. The current de facto plan, which is essentially the court-ordered plan, remains in place pending the evidentiary hearing which the court has established.
Your Honor, who would you like to draft the order?
You, Mr. Thompson.
Thank you, Your Honor.
You can get that circulated with Mr. Hawley as soon as possible, setting forth the rulings and dates and deadlines which have been established by the court here today.
Yes, Your Honor. Thank you.
All right. If there's nothing further at this time, this matter is currently in recess. This meeting may be ended for all at this time.
Thank you, Your Honor.
Modification hearings like this often come down to one thing: evidence. Work schedules, substitute care, household stability. All of it has to be proven, not just argued. Judges won't change a parenting plan without clear proof that the current setup isn't working or isn't in the child's best interest. With a full evidentiary hearing set, this case could shift depending on what each side actually brings to court. We'll be following how it unfolds. If you want more real family, court breakdowns and updates, make sure to subscribe so you don't miss the next hearing.